You know, we were talking this morning, and we realized that we've played a huge ruse on all you people, okay? Which is that, we build this as a regulatory panel, but we are really here to talk about Matt Levine, okay? Because Matt Levine has some great insights into what's really going on here. And Valeska, why don't I turn it over to you and tell us how Matt Levine just captures all of this before we get into the depths of it.
So following on from the last panel that was also giving a shout out to Matt Levine from Bloomberg Money, he has this theory on crypto that I think rings really true and is a good way of kind of explaining why there's all this craziness where people just aren't following the rules. And he says, look, there's this like drunk under the lamppost theory on crypto right now. You go to the SEC and you say, hey, what are we allowed to do? And they say, almost nothing. And then you do the craziest thing on the planet. You call it decentralized. You advertise eye-popping valuations and increases in profits. And he says, I don't want to give you legal advice, but look around. And his examples of that there are two of them. One of them is Facebook. And he says, Facebook tried to create a stablecoin. They go to the SEC and they say, okay, well, what do we have to do the stablecoin? We want to work with you. And Matt Levine's answer is, bring us the egg of a dragon and the tears of a unicorn. Right. And then you have this crazy company like Wonderland, whose founder is a known serial scammer, and the co-founder may or may not have faked his own death. They advertise an 83,000% return, and they kind of just get away with it. So it's basically what he says is, hey, look, you go to the SEC and you go to the regulators and you say, the revolution needs rules, and they say, yep, and you got them, and a lot of them. And then there's other people that just offshore everything and pretend there are no regulators and they're really decentralized, like, in DeFi or whatever they want to be. And they say there needs to be no rules and there aren't any rules, and they kind of get away with it.
And this actually reminds me that this might be a good time to let you guys know that in order to get their true feelings, we had to promise that we acknowledge that whatever they're going to say here are their personal views and not their views of their respective really awesome law firms, okay? So, but with that, there have been some developments since we last spoke here, right? And tell us about the cases that you think are important. You want to start off?
Do
you want to start off?
All right, I could start. One of the pivotal cases, I think, since our last conference, and one that probably the only precedent in the market today regarding initial issuance, is the Telegram case that was pending in the Southern District of New York. The SEC brought Telegram to court for a preliminary injunction, the basis that they were engaged in unregistered public offering, even though they relied on private placement exemptions, both Regulation D and Regulation S, in their initial offering. The court in that case, I think that's the only decision to date on some of these issues, concluded that some of the intermediaries, that the investors that Telegram had sold to initially were statutory underwriters, and therefore were effectively an intermediary step to distribution of the Gram tokens to the general public, and effectively was an unregistered public securities offering.
Is that bad?
Yes. So the challenge in that case, and in many other cases to date, is the SEC is very focused on the initial distribution and not on secondary trading and what happens to those tokens down the road, even if you are relying on an exemption initially. But those tokens do need to trade on secondary markets, be supported on certain blockchain networks, and how do they come into existence in compliance with the securities laws? That, I think what Valeska had said earlier, that there are registration paths, there's interaction you can have with the SEC, but there's also impediments in that there's lack of guidance on how to get to the ultimate end game in having some of these compliant tokens in the market.
Just to follow up on one of the things you were saying about underwriter status. So there is a lot.
Sorry. What is an underwriter?
Yeah. So that's so broad, unfortunately. And so they're basically like any person that's acting as a conduit for securities. And so in Telegram, that was because they were getting these securities, they were getting them at, what they said was like a deep discount, and they were going to be blowing them out. It was basically de facto that once they got these securities, the big institutional investors, they were going to be trading them on the secondary market. And you see the same kind of concept in the Ripple complaint. If you read through that, you'll see the SEC says, look, you guys were out there, you were selling these securities from like 2012, until like when they filed the case, and they called all of those offerings, every single one, an offering. The whole thing was an offering, and they looked at all of it. And they said, you guys basically were giving, Ripple, were giving discounts of 4 to 30% to these investors, and they were trading it right after that, sometimes on the same day. And to all these other people, they were acting as conduits. And so you'll see this concept of a statutory underwriter. One of the important things to realize is like maybe the SEC hasn't focused on that directly in Telegram and Ripple. They mention it, but they haven't pulled those people yet in as defendants. But if you are deemed to be a statutory underwriter and an issuance that is not compliant with securities laws, then you are also responsible. You could be a co-issuer, which means that you can be in charge or be, you can get fines, you can get penalties, rescission you could have to pay for, all of those different things. And if you look at the Uniswap complaint that was coming out recently, although the SEC hasn't said it, the Uniswap complaint says, hey, Andreessen Horowitz, hey, Union Square Ventures, you guys bought into Uniswap. You've helped promote it. You got these big discounts. You were statutory underwriters. And we think you should have to pay us back, us class action people, in charge of the rescission. It's not just Uniswap, you too.
So, show of hands, how many statutory underwriters are here in this room? None. Okay, good. Yeah. So, but that was like getting tokens at a discount and then selling them into the market. When the main drop happened. I mean, that was like shooting fish in a barrel, right? I mean, there has to be a consequence for it, right? I mean, because who was getting scammed there? The people who bought at that level.
Well, to think about it though, like if you're looking at the cases that are coming out now, those were cases that happened back in our like crazy ICO days, right? Like the SEC is reaching pretty far back into the past.
Right.
When you're reading the Ripple complaint, they're talking about things that happened, they're talking about a memo that came out in 2012. They're talking about trading and issuances that started in 2013. And they're saying, and usually you'll have like a statute of limitations, right? But if you read the complaint, it's like this from 2013 until we filed this case, every issuance you did was all part of one offering. So they integrated everything. Yeah. So when does your statute of limitations end? Like, they can reach back. That's not stuff today.
Exactly, but you can do that under the securities laws, right? There is basically no statute of limitations there, right, for illegal offerings. So that's like something to always, always, always remember, right? If you want to do something like that and think that you'll ever be able to sleep peacefully again, you're just dead wrong. Okay, so, but then there was also this other case with this big, well-known firm, called BlockFi, and they got into all kinds of trouble, and then like their head of trading left the firm, and what was that all about, and was that interesting?
Yeah, so I can touch on that. The BlockFi case is definitely has been headline news, and I think the SEC, as part of that enforcement action that's publicly available, noted that any type of lending offering to the retail public itself could be a security, irrespective of whether you're lending Bitcoin. That may not be a security. The product itself, when it's offered in return for a fixed variable interest rate, and the retail investors putting their assets at risk in exchange for BlockFi's efforts, could create both an investment contract that's a security, it could create a note, which is a security. Actually, in that settlement, the same product was both an investment contract and a note, according to the SEC settlement. But also, BlockFi in that situation, this is the first time the SEC had brought in the Investment Company Act, noted that BlockFi was operating a registered investment company on top of offering a registered security under the Securities Act.
Why was that?
I'm sorry?
Why were they operating an investment company?
Because they were taking in all of these borrowers from retail investors, pooling all of the crypto, and then reinvesting through other loans where they were on lending to other borrowers, which the SEC presumed in the settlement. That second loan was also a security offered by those borrowers to the pool. And that effectively made the entire pool of crypto assets an unregistered investment company that needed a valid exemption, which it didn't have. And in that settlement, the SEC proposed, and we don't know yet publicly if BlockFi is going to move forward with it, a potential structure on how they can move forward with a full registration with the SEC and also rely on potentially an exemption under the Investment Company Act in that structure.
One thing to know about, who knows what an investment company is in the crowd? So most of you think that it's like a venture capital fund, like a hedge fund, something that pools securities, right? Like you're buying and trading somebody else's stock, but there's also this concept under the 40 Act called an inadvertent investment company. So say you're a strategic company, you're like Google or somebody else, and you say, I want to start investing in companies. I want to have non-majority owned subsidiaries. You can, if you have more than 40% based on this test of your assets held in securities, and it's a comparably broad definition of securities, then you're an investment company. And it's basically impossible to be an operating company and also an investment company. So, and if you looked at, this was kind of foreshadowed in the DAO report that the SEC put out, back in like 2017?
In July 2017.
Okay, and there was a footnote in there that said, hey, by the way, it might have also been an investment company, this DAO.
So, but it seems to me like based on the cases that you guys just mentioned, right? That'd be really cool if you could had this concept of creating a product where there were no people behind it at all. You know, it's just like this cool like collective ideas, you know, that somehow got interspersed via the internet, and comes up with a product with no lawyers behind it whatsoever, and you can trade it. Does that exist?
Oh my God, that's such a great idea.
Yeah, we should do it, right?
We should. I think somebody did though. It's called decentralized autonomous organization, a DAO. Oh yeah. So there is. So there's a few problems with that as well. One of the things that you'll hear when you call up your corporate attorney is they say, well, that's like a lot of people all pulled together making decisions. It kind of sounds like a partnership. And it kind of sounds like all of you people could be responsible for everybody else's liabilities and the liabilities of the organization. And that's when you hear people start talking about, okay, well, maybe we'll do like the Wyoming DAO, or we'll do something like that. But the idea is, it needs to be part of an organization, and it needs to be part of an organization so you can limit the liability of all the participants in it, right? Because they're all going to have governance tokens. If you're voting on it, you're probably a general partner in a partnership and responsible for all the liabilities of it, to the extent it's not an organized group, part of like an LLC or a C Corp or a Wyoming DAO. And the other thing that comes up pretty frequently is you're still going to be putting securities into it for the most part. So then you got to make sure it's not going to the wrong people, because most of them aren't registered securities. It probably also has 40 Act problems. And when you need to do that, you go back to, okay, well, I really need to have a permissioned DAO instead of a permissionless DAO, because I have to KYC everybody coming in, do the KYC, AML compliance that you guys do. And then I need to make sure they're accredited investors unless I'm going to be registering them.
And just to follow on, I think a lot of DAOs or DAO structures are used for decentralized finance products to create compliant structures or unaffiliated structures. But these DeFi protocols also need to consider what exemptions they rely on, even if they're decentralized. The governance token holders and others need to consider, do they have a proper exemption under the securities laws if it includes some type of distribution of tokens. It needs an exemption from Investment Company Act if it involves pooling certain assets and distributing and investing those assets. If it's a decentralized exchange that may trade and support tokens that might be securities under U.S. securities laws and has U.S. investors, it needs to consider whether or not it has an exemption from that being a national securities exchange registration or broker-dealer registration, both of which are triggered, and we've seen the SEC focused on in the DeFi context. And if it's a decentralized lending platform, the BlockFi being a centralized product, but in the decentralized lending space, the same regulations apply. So you need a valid exemption, both in the Securities Act and Investment Company Act, to the extent you are doing a decentralized finance lending product. And we have seen people creating these structures in a compliant manner, making sure they're permissioning certain participants to rely on those exemptions.
Wait, so DeFi's are actually can be legal?
Yes, surprisingly so.
But look, the ones that I've seen, I just look at them and I go like, no, this is total garbage. You know, this is an illegal securities offering. Everybody's piling into it. Nobody knows who those people are, so you can't know that these people are accredited.
And certainly a lot of them have started out as such, but I think as more institutional market participants are coming into this space, they're demanding permissioned DeFi protocols because they themselves may be registered investment advisors that can only deal with exempt market participants. They may be still subject to the Bank Secrecy Act or concerned about Bank Secrecy Act and sanctions compliance because they're in the US, so they're not going to interact on these DeFi protocols unless they know there's this permissioning and controls that help them stay in compliance with their existing regulatory regimes. I think most of the non-compliant products we see are retail focused, where they're not institutions that are regulated that are demanding the controls.
Then the D part of it goes away, doesn't it?
I think you know, at least market participants that I've seen can still have decentralized products, but with permissions that allow only certain market participants.
But who gives the permissions?
The way the protocol is structured can permission, but there's often some type of intermediary that's involved that helps maintain the permissioning. That may, let's say it's a lending pool. They may do the diligence on the counterparties to ensure they're only satisfying a credit investor or qualified purchaser status. They may have tools that they deploy to check for sanctioned persons, sanctioned countries. So there definitely needs to be certain intermediaries that interact with the protocol, but doesn't mean the protocol itself can't be decentralized.
Okay, and then what happens when one of these decentralized instruments, right, like what you invest in, like what happens if something goes wrong? Who do you call?
So, and this is, I think, a big misnomer, is that code is law. There was a lot of that for years, and that the smart contracts and the protocols don't know how to deal with what happens, something goes wrong. We always advise clients to have very good written contracts, documentation, terms and conditions as to what happens in the event and who's responsible in the event something goes wrong in the process, and support in written contract legalese the terms of what governs and who's responsible in a decentralized environment. I don't know, Valeska, if you have.
No, it's the same thing. I think like there's no statute anywhere. There's no case law anywhere that says that code is law. It's just not a thing. I mean, it's a catchy phrase. I like the phrase. But the reality is the laws are the same laws they've always been, unless Congress is going to change something and put something out, which they haven't yet. So really, it is going to be looking at the terms of service. You know, that's especially important for things like NFTs. Like, what are you getting? What are your rights? Do you have the right to display this NFT? Do you have the right to reproduce it, copy it, move it? Like, what are you getting? And all that is in terms of service. You know, that's just like one example. But for all of these products, you need terms of service. And like when you're looking at like a normal widget, you have a sale contract, you put in that sale contract what you're giving the person and what you're getting. So, you know, on one hand, the SEC tells you that these things are securities and they are for purposes of the SEC, but that is completely irrelevant. And when you're looking at like, what is the product and product counseling and like, how do we deal with this product and the rights that we're giving you? And that's a totally different area. In that respect, you need to stop thinking about the securities concept because it's not equity when we're talking about these products. I mean, it can be tokenized equity. But for the most part, if we're talking about these things, it is terms of service is the contract that's governing the rights that people are getting.
So do you find that people actually, like what kind of people get into trouble by not thinking about this stuff, and what distinguishes one creator from another when it comes to like your own experience with these new fangled products that are coming to market? How do people end up in your office?
Everybody ends up in our offices. You know, it's strange because it's so regulated. You know, when do you have a product that is also a security, there are instances, right? Like people that are pooling real estate and selling it in certain ways, they can have that and they're familiar with it. But for the most part, when you're selling art and when you're selling services, you're not thinking about that. It's a newer concept. And so, yes, there's been disruption, but because you've made financial markets float and you create this liquidity, that has changed the ballgame. And so you have to be thinking about it and all these different things. Like nobody sells services and thinks, wow, I might be a 40 Act company until you get into blockchain. Nobody sells services and thinks my services might be a security, very few people, until you get into blockchain. So there's all these different areas. Sure, when you start getting into fintech, people assume that fintech is going to require this stuff. But outside of fintech, where you don't have people that are used to the broker-dealer rules, it's hard. And so it's been an education for the field to say, hey, you guys, there's so many things you need to think about. People are kind of surprised when they come up with an NFT and there's a product counsel telling them, oh, you guys need terms of service. And they think, why? I'm just minting some tokens on OpenSea and throwing them out there, and there's some pictures I'm going to do. It's cool. It's just art, but it's not just art.
And I would add just, I think we've been talking a lot about digital assets that may not be securities. I want to focus on digital securities for a second because I have a lot of clients coming in saying, how do we do compliant, true securities offerings, and what's the market infrastructure to support that? So that might be tokenized equity, debt, maybe tokenized real estate products, some as securities, some as not, tokenized bond offerings. I think that there's a lot of benefits for tokenization of traditional security products, and I work with a lot of market participants on both the issuance but also the broker-dealers that need different permissions, that need more guidance from the regulators on how to create the secondary infrastructure to support the digital securities, that those that want to do things in a compliant offering perspective need to support the market. And on the broker-dealer side, there are broker-dealers that already worked with that support primary issuance, secondary trading of digital securities. I think at this conference we've heard from a number of ATSs that are supporting trading of digital securities products. The one impediment so far, and still working through on how to advise clients on this area, is custody of digital securities through a broker-dealer. We have not seen yet the SEC approve, or nor FINRA, any broker-dealer to custody digital asset securities. There was this custody statement that came out in December 2020, almost 2.5 years ago, with a 5-year statute of limitations. And the SEC, there's been a number of applicants in the pipeline that I've worked with for more than a year, and the SEC has not yet approved any of those market participants. I think that's one of the biggest impediments in that area. As to how to create a real market infrastructure to support the digital securities market as we're seeing that area evolve.
But one thing to point out is if you go back to like 2016, 2017, 2018, there wasn't a registered ATS, right? Yep. There was nothing. So if you wanted to have this compliant digital asset that was a security, like what would you do? There was nowhere to trade it. Now there are ATSs, and that's amazing. And so I think we should sit back and think like, wow, the market has come so far. Look at what we have now that we didn't have 5 years ago, and it's really impressive. And we used to say, hey, there's no ATS. Now we say, okay, well, liquidity is coming up. So now it's, how is the liquidity doing on these markets? Not do they exist in the first place?
No, excuse me, that to me is a really good point, right? So things have moved along, right? But to your point, right, they have moved along as fast as they could have moved along, right? And we should really be spending a lot of time thinking about how we can effectuate that change that we want to see.
So I think the SEC is probably going to do some of that for you. Like the key is those non-compliant exchanges, because once you have things like the Uniswap case where class actions are coming out and suing people over them because they're not compliant.
They're suing who though?
So Uniswap is an exchange.
Okay.
And they're a pooling exchange. They're not like a bid-ask exchange, so it's decentralized exchange. But it's like a way to be trading these things where you don't have to be compliant on an ATS. I mean, not a compliant way, obviously, but a way to do it. And so if you start cracking down and tightening the screws on the people that aren't complying, and the reason they're not complying is because they want to be on those exchanges where they can just do whatever they want to do and not comply. And those exchanges are enabling it. So once those kind of get cracked down, then everybody's forced to start being more compliant and forced to start working with the ATS. And I think that's kind of crucial.
No, and we have a lot of partners. Some of them are here in the room that spent a lot of their treasure on getting to be compliant, right? So, I mean, in I don't know, as an investor, I'd kind of want that nice stamp of approval saying, yeah, okay, you guys are regulated, you guys have to keep records, you guys have to be subject to examinations, you probably have a few compliance officers, like I know that I'm not entering the Wild West here when I'm taking a huge amount of money to you and saying, please trade this for me.
Yeah, and I think, what happened last week with Terra and Luna, like having retail investors significantly harmed pushes the regulators to start moving faster, I think.
Yeah, and the concern with the regulators, though, and I talk a lot of market participants that want to go in and register and have compliant paths forward with the SEC, is that there are areas that may require more relief and flexibility in supporting the tokenized technology with the regulators, while it takes a lot longer to work with the regulators to create that compliant path as opposed to launching some of the products that are kind of already in the market that may not have gone down that path. And the SEC's focus and priority right now is come in and register, but really we're going to crack down through enforcement, and there's a lot more resources being allocated to crypto enforcement. SEC just renamed one of its cyber unit divisions to Crypto Asset and Cyber Unit Enforcement, and will double its staff. So the resources being shifted to enforcement suggests more people need to come into compliance, but there's not enough proactive engagement with the staff to be able to come up with compliant paths forward, which is an interesting conundrum and challenge that's being created.
Also, if you look at the economics from like a regulatory standpoint, if you have to sit there and think of the rules and write the rules and come up with them for all these nuanced situations, then somebody can do something you don't like, and you're constantly fixing loopholes, a little bit of cat and mouse. But if you just do regulation by enforcement for these new fancy products, and then you fine BlockFi $100 million, BlockFi has effectively paid for your regulation. Now we know they have, right? Like we know how to do these lending pools now, and we know how to do it because BlockFi paid for it, and they did go in and they worked with the SEC on that settlement. But the SEC didn't have to pay for it; BlockFi did.
Yep.
That's an interesting take on it. So, but do you see, like, you guys are on the forefront of people coming to you with brand new ideas and saying, hey, how can we do this right? Are there any like newfangled products that you guys are seeing that we haven't really talked about at this conference that perhaps we should be talking about, or have we covered it all?
I think one thing I've been seeing a lot, and I don't know that I would call it a newfangled product, but we had ICOs, and now what we have, I see a lot of our safes coupled with a token warrant or a token side letter, right? And so you have a really kind of, in a lot of ways, very similar to what you were doing in the ICO days. You're still putting these warrants out there. And to the extent these warrants don't have exercise prices that are tied to the fair market value of the token, then there's a good chance that you have exactly the same situation you had with Telegram, exactly the same situation you have with Ripple, where, Ripple, they're in the complaint when they're listing out the facts, they say the discount was 4 to 30%. Okay, but if you're putting this token together for a company that's doing a safe, that's like a pre-seed company. They have no token. Who knows what the value is? By the time they launch that thing, to the extent the markets maintain, right, that discount's not going to be 30%. It's not going to be the high range of Ripple. It's going to be a massive discount, and there's a good chance it'll be like an 80% discount. So you're right back into that statutory underwriter problem if you're not pricing it the right way, if you're not building in the restrictions. So I do see, like, now there's been a big move, and in 2017 everybody said, like, it's not a security, you had to really convince them. There's not that concept anymore, but now the question is, how do we make this, sure, we're going to say it's Reg D compliant, but that doesn't just mean you sell it to accredited investors. There's also obligations issuer side under the rest of the Reg D rules that put an actual onus on the issuer to make sure they've exercised reasonable cares to prevent the secondary markets from evolving in a way that they shouldn't. And the way they do that is they say, hey, you have to exercise reasonable care to ensure that the people getting the tokens aren't underwriters and they're not statutory underwriters. So that goes back to kind of the beginning of this with the trading. Like, how do we make sure these people aren't statutory underwriters? How do we restrict those securities once they get in your hands? And you can't just say, like, as long as we sell it to an accredited investor, we're fine. You've got to follow the rest of the rules.
And in my world, I would just also add, I think early on, 17, 18, a lot of the use cases, we saw a lot of use cases, but the ones that survived the last several years were in the financial services space, whether it's digital securities, payment tokens, stable coins, all financial services focused products. What I'm seeing now is a trend to more use cases in other industries, huge increase in sports, media, entertainment in the blockchain space, especially with the rise of NFTs and other ways to integrate certain features and IP rights into the blockchain technology and deploying it in that industry. Rise of real estate and other real-world assets that are being tokenized and deployed on a blockchain. But in that situation, you have to really consider UCC commercial laws, state-specific regulations that didn't really exist when you're just creating a cryptocurrency that doesn't have any underlying assets. Now we have to integrate real-world regulations on a state-by-state level to deploy some of those offerings. And then the last area that I think is probably the slowest moving is healthcare. And I think probably that's the next evolution, but because it's such a highly regulated industry, we may see more development of integration of that technology, but on a slower scale because of how much regulation will need to apply to distributions in that industry.
I think also people need to remember that, like, blockchain is not just always only about trading and liquidity. There is a lot of back-end technology that is blockchain based, and that might be some of the stuff that moves into the medical space, because you got to think about the market. Like, what's the use case for blockchain in one industry might be completely different from another industry.
That's great. Well, so we were discussing this earlier, which is that both of them have watches on, right? I haven't worn my watch since like March 2020. Yeah, so I'm glad to see that they're making a comeback, and it's also reminding me that we are out of time, basically. But I did want to see whether you guys had any questions for the panelists. So that would be great. Please, sir, go ahead.
I think it was in January the SEC came out with a proposal changes to Reg ATS based around or titled under changes to fixed income, but actually it included any protocol that's used to communicate not just orders but trades between people. That was, to me, was very subtle. Can you talk about that?
Yes, I can cover that. So what happened is there was a proposed amendment to broaden regulation ATS. It was focused on fixed income. There was no discussion in that release regarding blockchain digital assets at all, and had a very short 30-day comment period. And a lot of the industry, especially DeFi, and because...
Wait, sorry, that was 30 days to comment on a 600-page release.
Yes.
Okay, so...
and a lot of the industry kind of went out publicly and said they're trying to target blockchain, DeFi, because there was a broad definition of ATS that included any type of communication channel. Even using like a chat function in discussing a securities transaction may rise to the level of requiring registration. And so a lot of the industry commented and pushed out a lot of comments regarding the impact to blockchain industries, other technologies that the SEC was broadening it, going beyond its authority under the Exchange Act, which is what regulation ATS is promulgated under, to capture this industry. Since then, the SEC has reopened for a longer period of time the comment period. But following that Reg ATS, the SEC also put out a release for comment to expand the definition of dealer, which they actually in that release did footnote, and this applies to digital asset securities. And then after dealer, there was one other, securities-based swap proposed guidance too that came out that also footnoted, and this applies to any securities-based swaps on digital assets that might be security. So since that Reg ATS with no mention of blockchain, they have since incorporated into their practice to mention, and this applies to this industry as well.
But it really is that ATS release it truly was supposed to expand the people captured by regulation ATS to include treasuries. That's, that they've just expanded it now once they've figured out that, they missed something, and they put that into other releases, all with very short comment periods. Yeah, so. William.
We've heard a lot from you about sell-side constraints, exemptions, and whatnot. And all of these rules are promulgated by SEC under the general heading of investor protection. And one way to look at accreditation is as an exemption on the buy side. Now, none other than Matt Levine has proposed an alternative type of exemption there. I believe he called it the "I want to make stupid investments and lose all my money" exemption, where the SEC lets you fill out a form and declare that you are ready to do those things. And they then certify you, maybe they put that on the blockchain someday, and you are then exempted from the normal accreditation process. I'd love to hear a little bit from you about that sort of thinking of the buy-side exemption.
I think that's a great idea, but in addition to the form that's filled out and filed with the SEC, I would also ask that you make a video and upload it to YouTube, okay, so that when you do lose all your money, okay, you don't get to complain and whine about it. That's always the case, right? Like this happens in every down market, right? In every down market that I've seen in my adult life, it's like the retail investor who was getting a great deal, right? Or says that, oh, I was duped by the bank or the financial institution into buying this stuff that made me money until it didn't. And those are the people that they worry about.
So to your point, all investors aren't the same in the SEC's eyes. That's not what the rules were written for. In fact, you have this definition of underwriter that's specifically broad, so that people that are big investors that are just conduits for the securities, they're not treated the same way, they're not protected the same way. So like your big institutional investors, you have a concept of, a 144A offering that you can do to QIPs, which are qualified institutional investors. These are huge investors, which are kind of to Matt Levine's point of just being like, I can lose all my money, I don't care. They have, faster resale periods. They're able to turn things around differently. Those are kind of some of the offerings you do when, you're doing an offering in the US and you have a company that's listed in like Canada or UK or something like that. And the premise is there's these big guys and they don't need the same amount of protections. When the SEC is like, has the Ripple case and they're talking about, they treat differently, right? The big institutional investors that got the initial issuance, they did in Telegram too. There's these big institutionals that are blowing out the securities and they're treated differently than the retail investors. And the risk is not so much to the big institutionals that got a big discount and locked in a price, right? Like they got a 30% discount, they blow out those securities the same day. The chance that they're harmed is minimal. But who are they harming? They're harming the retail investors. And that's what the SEC is worried about, because the retail investors are the ones that are out there. They buy it not at the discount, they buy it and they're noise trading it, and they don't have any disclosures. Nobody's helping them out there. And so, if there is that form that's like, hey, I don't care if I lose all my money, that needs to be something that's going to those big quips, those big boys, like know what they're doing, not to the retail investor who's like, doesn't really, the meme stock traders shouldn't be treated the same way under the securities law. That's just how the policy is like your big institutionals that can afford to lose money. And there are also, a lot of them are funds. And they have fund investment documents that will disclose to their LPs what type of securities they're investing in. And they're fiduciaries to those groups, right? And if they say that same thing, if they say, hey, we're gonna invest in super crazy risky stuff, you could lose all of your money. Like that's not the fund that like CalPERS is gonna be investing in. you're going to have CalPERS investing in more ones that have disclosures that are like, hey, here's our risk management strategy. So there's different types of funds and different type of investors, and they need different protections. I don't know if that answered your question, William, for you.
It illuminates your thinking, so it does answer my question.
Great. Well, I don't know if there are any more questions.
One more. Is there any thought going into what qualifies an investor? An accredited investor right now is based on net worth and things like that. I mean, there are a lot of people that probably don't meet those net worth requirements that have gone through their Series 7, young people that are working in the industry and they don't meet those requirements yet. Is there anything coming down the pipe that way?
So the rules for like what meets the accredited investor definition have been on the books for a long time. And when there is chatter from the SEC that I hear about what they're going to do with that definition, it's usually like, should it be inflation adjusted up? Not kind of the opposite way. And oh, go ahead.
No, go ahead.
I'm thinking more of like an educational or some type of exam that could be taken to make, instead of having, your net worth determine your qualifications, rather your education determine your qualifications.
So in the fund world, there's something like an employee that is sophisticated that can be part of the fund's investment strategy, and the funds people know more about that. There is a concept that you could technically have 35 unaccredited investors, and they have a sophistication standard along with that. Nobody does that in practice because having unaccredited investors causes so many problems in your offering for Reg D purposes. You have to have disclosures. Those have to be vetted by counsel. And then you also, every time there's a decision to be made, if you're selling that company and the buyer is giving securities and stock in that, like how does that, every time there's a point, they now have to issue to an unaccredited investor. When they're selling the stock, if they have to make a decision about it, every decision they have to make in a stockholder consent, you have to worry about if they're sophisticated or accredited, and there's another level of diligence. For blue sky exemptions, it's harder to get some blue sky exemptions if you do that unaccredited investor. Always using accredited investors just makes your deals a lot easier, and any big law firm you go to will just say, no, we're not doing it. If you're going to try to do that 35 unaccredited, I just say no.
Yeah, and I would just also add maybe something related to what you're suggesting in your question. For broker-dealers, they may be involved in offerings, but they also have, depending on who their investors are or who their customers are, certain suitability obligations. So even though an investor meets the accredited investor standard, in order for a broker-dealer to be involved in offering a product, they need to separately determine if that product is suitable for that type of investor. So it's a mom-and-pop investor and knows nothing about blockchain and crypto, and even if it's not a security and they're offering them crypto, they need to make a general assessment, is this product appropriate for the sophistication level of that investor, versus maybe there would be a young tech customer of theirs that may not meet accredited investor standards, but is this crypto product that might not be a security, maybe more appropriate to offer to them rather than the mom and pop. It's really early stages where broker-dealers are starting to think about and how to market and support these products, and it requires a lot of interaction with FINRA to get them comfortable for a broker-dealer to offer them. But that's also another check on top of the accredited investor standard that intermediaries need to have.
They are considering looking at certain qualifications to allow people to participate in the industry that would help be towards being an accredited investor.
Yeah, they just haven't adopted them yet. You're right, right? They're talking about people who've worked in finance, that kind of stuff, right? Who've shown that they understand this stuff. But again, to her point, which is that even if you meet that, it may still be that the broker-dealer that's doing the offering for the issuer may still say that, hey, that's all great, but we don't think it's suitable for you. We can't justify it. And then in that case, so this happened at my old employer, right? There was this man by the name of Bernie Madoff, right? And he came into the office one day, and he told our CEO like, yeah, I know you guys are a big Swiss bank and all of this stuff, but you guys are asking too many questions. So, like, you don't have to offer my product to anybody, right? And then, of course, people came to the private bank and said, typical you won't let us get into the hottest thing there is in the market and stuff, like, how dare you? And then we made them sign a letter saying, yeah, I'm really stupid, to William's point, right? And, those are the same people that got ripped off. So, like, sometimes suitability checks are a really good thing to protect your own clients, because if you're a financial institution and you don't do that, then what is somebody really paying you for?
And just to follow up on that, like, just because you can do it, like, there's technically a rule that allows you to do it, doesn't mean that there aren't other rules that make that thing impractical or just so expensive for lawyer time. And when you're thinking about, am I going to allow these unaccredited investors, whatever number of them, to invest their like $5,000 or $1,000 here or there, outside of the Reg CF context, and incur all the related legal fees and expenses and headaches down the road, like, for what and why?
Yeah. So, folks, we are officially out of time. So thank you so much.